Police are getting a new tool to help them test for drug-impaired drivers. Ottawa has approved the use of the Draeger Drug Test 5000. That's the roadside saliva screening equipment, which will be used by police to test for the presence of THC, the main psychoactive agent in marijuana. The manufacturer says it can meet demand for the equipment within 4 to 6 weeks. There are concerns, though, that the device isn't suited for our cold Canadian winters. It has also been found to yield a fairly large proportion of false positive and false negative results. For a closer look at the test and potential legal concerns, Michael Spratt joins us. He's a criminal lawyer based in Ottawa. Good to have you on the program. Hello.
Good afternoon.
So let me start by, what you think of this device with all the concerns that I just mentioned.
Well, there's a couple problems with it. And the major concern is the amount of false positives and false negatives that the device generates. This is a tool that the police use to justify more invasive investigative techniques. If this machine says that you have cannabis in your system, that gives the police grounds to potentially handcuff you, detain you, take you back to the police station, and extract blood from you. And what we know is that studies show that the machine is going to get that wrong 15% of the time.
So, and this test can't, as we understand it, be used as evidence in court.
That's right. The test is just sort of a gateway. It's a roadside test to provide the police the reasonable grounds they need to do these more invasive things. So although it's never going to be used in court, it still can represent a constitutional intrusion, an unlawful constitutional intrusion on the person in terms of a detention, and what can be a quite invasive search. And we have to also remember that failure to comply with the police's demand to submit to this type of test, a test that is unreliable, that gets it wrong either way 50% of the time, so gets it wrong 30% of the time in aggregate, is an offense in and of itself and can lead to criminal charges.
So given what you're just saying about in terms of the delay and the invasive nature of the tests, after that, would you see this as facing some court challenges fairly soon after implementation?
There will undoubtedly be court challenges. Fairly soon, probably not. We have to wait until these matters actually get to court, so it might be up to a year until we see the first challenges in our provincial courts. But by then, the damage is going to be done. Out of every 100 tests, 15 people who have no THC in their body will be further detained and subjected to either further impairment tests or possibly even having blood forcibly extracted from them. And so in that respect, the damage will be done. And we know from other studies that it's disproportionately racialized and marginalized individuals who suffer these sorts of consequences. So it may be years until we hear from the Court of Appeal or from the Supreme Court a final decision on this. And in the meantime, I think that Canadians are going to be subject to what will be found to be an unconstitutional intrusion based on an unreliable and untested device.
It's interesting, too, Michael, that when you talk about breathalyzers, there's a level of impairment that they can, conclude from that. But there doesn't seem to be a level of impairment, just instead the presence of THC using this device.
And that's one of the real problems that we have going back to sort of first principles at the very beginning of this move to regulate marijuana. Because THC, the government can't even tell you what level impairment occurs at. In fact, in their regulations, they say between 2 nanograms and 5 nanograms of THC, which is a criminal offense, that might not necessarily even correlate with impairment. So you have a device that can't tell how impaired you are, that gets it wrong 15% of the time, and we know, unfortunately, will be used disproportionately on some of the most vulnerable Canadians. That's a recipe for a constitutional disaster.
So, and then given all of that, is it better to not use it? And I guess I'm asking because nobody wants impaired drivers on the road. But without this device, then the police really aren't armed with anything else.
Well, that's not exactly correct. I mean, already right now, people are unfortunately driving with THC in their system. The legalization of marijuana isn't going to radically change that. And the police do have tools. There are field sobriety tests that the police can use to determine if someone is impaired by drug. It's currently a criminal offense to be impaired by THC. And the police do have tools and do prosecute that. In the grand scheme of things, we would all prefer that no one have THC in their system. But what the research does tend to show is that in terms of level of risk, drinking is much, much worse, and probably being on your cell phone and distracted driving is much, much worse.
Yeah.
So I think we really need to look at is this unconstitutional and unreliable device, is that going to create more problems, more delays in our courts and more challenges than what it's attempting to cure?
Yeah, interesting to get your thoughts on this. Michael Spratt, appreciate your time.
No problem, anytime.